Hello, I would like to welcome you to our webinar on domestic contracts, helping you avoid family law problems, which is hosted by METRAC Action on Violence with guest speaker Valerie Dye from Dye Law. My name is Andrea Collins Fitzpatrick, and I am the Legal Director for METRAC's Community Justice Program. I would first like to start with a disclaimer by reminding you that this webinar is for general information purposes only and is not legal advice. The legal information provided is not intended to be used as legal advice for a specific legal problem. The webinar will be recorded and reflects developments in the law before today, March 5th, 2025. It will be posted on our website at onefamilylaw.ca along with the PowerPoint slides. I would like to begin with a land acknowledgement. We acknowledge that this land is the traditional territory of many nations, including the Huron-Wendat, Haudenosaunee, and the Mississaugas of the Credit. Today, the meeting place of Toronto is still home to many Indigenous people. We honor all the First Nation, Métis, and Inuit people living on this land. We recognize the traditional territories on which our organization is located and on which our programs and trainings take place. Before I move to our presenter, I would like to tell you a bit about METRAC. METRAC works to end gender-based violence across communities through education, research, and policies. We have been in existence since 1984, so over 40 years, and our programs are devoted to advancing safety, justice, and equity. METRAC's Community Justice Program provides legal education and information related to gender-based violence. Through our Access to Justice program, we provide legal information in areas of family law, immigration law, criminal law, employment law, and human rights law. This webinar is part of our Family Law Education for Women, FLU, series. FLU's resources are available in 14 languages, ASL videos, and accessible formats. You can visit our website at onefamilylaw.ca, that's onefamilylaw.ca, for more information on your family law matters. I'm very excited today to have Valerie Dye to speak to us about domestic contracts, helping you avoid family law problems. And before I introduce Valerie, I would also like to thank Kenyan, our Justice Program Coordinator, for running the PowerPoint presentation today, and our technician, Ferdinand. I would now like to introduce you to our presenter, Valerie Dye. Valerie Dye is a sole practitioner at Dye Law. Her practice focuses mainly on family law, real estate, and wills and estates. Valerie has also taught business law at Toronto Metropolitan University as a sessional instructor. Valerie was first admitted to practice law in Guyana, where she practiced briefly before moving to St. Kitts and Nevis, where she worked as Crown Counsel for the Ministry of the Attorney General. She later attended the University of Manchester in the United Kingdom, where she obtained an LLM and a PhD in law, and where she also taught for a number of years. Valerie also taught at the University of Liverpool online LLM program. Valerie also taught at the University of Liverpool online LLM program. Valerie was called to the Ontario Bar in 2013 and has been in solo practice since February 2014. Please enjoy the presentation today. I'll now pass things on to Valerie.
Thank you very much, Andrea. And it's an honor to be able to present to you again. And I trust that what will be said in this webinar would be of real importance, major influence to those who will listen and hear what I have to say. And so today what I will talk about is domestic contracts generally, helping you avoid family law problems. And so just by way of summary, the topics that I will cover are: what are domestic contracts, the benefits of domestic contracts above going to court, different types of contracts, what are the requirements for a domestic contract, and can domestic contracts be set aside? So let's talk about what are domestic contracts. Now, family law in Ontario is regulated by various legislation, including the Family Law Act, the Divorce Act, the Children's Law Reform Act, and several other pieces of legislation. The main ones are the Family Law Act and the Divorce Act. The Divorce Act is a federal piece of legislation that relates only to parties who are married to each other. And the Family Law Act applies to Ontario. Each province has its own Family Law Act, and there's the Children's Law Reform Act that deals with parenting. And so these acts have provisions that will regulate what happens in family law proceedings when parties have to go before the court. And so basically the court will decide based on the provisions of these acts. Now, unless parties have made an agreement or a domestic contract, they are bound by the provisions of these legislations. But what it is important to note is that litigation in family law, litigation is not the only way that parties can settle their affairs. And I think many people assume that once there's an issue, the first place to turn to is the courts. It is not the only way to settle family law disputes. You can enter into a domestic contract, but even though I'm speaking to you about domestic contracts today, that is not even the only way. There are things called collaborative family law. Some lawyers specialize in practicing in collaborative family law, and there are various other ways that parties can settle their issues apart from going to court and engaging in lengthy litigation. And so domestic contracts are agreements between two parties to regulate their family law issues outside of the court. So what are domestic contracts? Section 52 and 59 of the Family Law Act outlines the provisions related to domestic contract. Section 52 and 53 refer to the making of marriage contracts and cohabitation agreements. And Section 54 deals with separation agreements, while Section 59 deals with paternity agreements. Now, when we speak about cohabitation agreement, I just want to make a note that a cohabitation agreement will become a marriage contract if parties later decide to get married. So cohabitation agreement is an agreement that is entered into between parties who are not married but are in a common law situation. So what are the benefits of having a domestic contract? So when there's a domestic contract, parties have the opportunity to determine their own results. Now, we all know, those of us, who've been involved in family law situation, who've been involved in going to court, we know that family law is very contentious. We know that it is a very stressful process. It is also a very lengthy process. And so engaging in a domestic contract allows parties to avoid the contention, the bitterness, the fighting. It also allows parties to enjoy the stress of going before the judge time and time again. It also helps you avoid the lengthy process. Family law processes can take as much as 3 years or even longer, because right now court dates are very far apart. You may go to court today and you may get another court date that is 4 months, sometimes even 6 months down the line. So it's very lengthy and it can stretch out for years. So domestic contracts that help you avoid that lengthy process, because throughout that process you're still undergoing that stress and that uncertainty. Also the expense that is involved in going to court. A domestic contract, it will involve some fees, some legal fees, but nothing in comparison to having to go to trial, where you can spend, some parties spend close to $100,000 by the time the family law process is over. And so there are definite benefits to having domestic contracts, because it helps you avoid all of these issues related to litigation. But of course, one thing to note is that a contract, it's an agreement, and it's just as it says, parties have to agree, because both parties will enter into that agreement and they have to be on the same page with regard to the terms. And so we cannot have a domestic contract unless parties agree to the terms of that contract. And obviously, if there's no agreement, then we cannot have a domestic contract, and we have to allow the courts to determine all the issues, which, may not be favorable to either party or to one party. And so let's talk then about the different types of domestic contracts. There's several types. There's a separation agreement. There's a marriage contract, which is often referred to as a prenup or prenuptials. There, the cohabitation agreements. There's a paternity agreement, the family arbitration agreement. Some of these are not as common as the others. So we'll start off by talking about the separation agreement. This is the most common domestic contract, the most popular, I guess, because at the time of separation, parties may consider the possibility of doing a separation, putting everything in writing and regulating their own affairs. So in preparing a separation agreement, parties negotiate and they agree on the terms of the separation. And what it does is that it allows the parties to, as I said before, you're able to avoid a lengthy court process and you're able to avoid the expenses of a trial. And so when you do a separation agreement, you can agree on all aspects of the marriage or the cohabitation and the breakdown of that relationship. And once that is done, this agreement will have the same weight as a court order, provided that all the requirements are followed. So some of the examples of some of the things you can put in there, you can determine if there are children, you can determine the amount of child support, you can determine parenting, decision-making, whether decision-making will be sole decision-making or whether one person will make decisions. You can determine whether spousal support will be paid. You can determine how property will be divided. Basically, anything that a court can decide can be decided in a separation agreement. There are exceptions and limitations that I will refer to further down in the presentation, but it's just to say that it has the same effect as a court order because our legislation provides for separation agreements and other domestic contracts. So the other type of domestic contract that we will look at is the marriage contract. Now this, and I would add, unfortunately, is not as popular as the separation agreement. And I will tell you why I think it's unfortunate. When parties are separating, the relationship has broken down. To have a separation agreement, there needs to be an agreement between the two parties on the terms of that agreement. When a relationship has broken down, it is not always easy to agree on the terms of a separation agreement. There's this bitterness, there's anger, and it's difficult. Of course, lots of people do agree and they settle their affairs, but many don't because the relationship has broken down to such an extent that parties don't even wish to speak with each other. With a marriage contract, on the other hand, you do a marriage contract when you're about to enter into a marriage, or you can also do one when you're already in a marriage. But the key is that at this stage, the relationship is strong. It's easier to agree and to determine how you will deal with your issues in the future in the event of a breakdown. It is much easier to agree on that. But why I think a marriage contract is crucial is because you can make provisions for certain things that would be more difficult for you to address at a breakdown in a separation agreement. What is an example of this? Let's say, for instance, Party A and Party B are getting married. Party A has a property before marriage. They might have had it 5-10 years before. And when Party A marries Party B moves into that property. And that property becomes a matrimonial home. And because it's a matrimonial home, even though Party A had this property before, if they separate, that property becomes part of the net family property of Party A, and it is subject to division, which means that party B will be able to get a share of that property, even though party A had that property prior to marriage. Now, at the point of marriage, it is possible for party A and party B to have a marriage contract in which they state that despite the fact that the laws of Ontario allows party B to have a share of that property if there's a separation or divorce, they can agree that that property will not be subject to division. It will not become a part of parties A net family property asset. They can decide that. Now try telling that to party B at the stage where they're breaking up and they're angry with each other. It is not easy. It's not likely that party B will agree not to have a share in that property. It's easier for that agreement to be reached at the stage where they're about to get married or where they're married and the relationship is still strong. You can have party B agreeing to not have a share in party A's property. And so, to my mind, it's very important to have a marriage contract. Parties can also determine their spousal support obligations. They can determine from the outset that if the marriage breaks down, neither party will seek spousal support from the other party. They will wish to be totally independent of each other. So they can determine that before they get into a marriage or during the marriage, and preferably when the relationship is still strong and there's no issues in the relationship. But a marriage contract has to be done before there's a breakup. Even though you can do it during the marriage as well as before the marriage, once there's a breakup, that's no longer a marriage contract. What you should do is a separation agreement. So apart from the property issues and the support obligations, as well as not only spousal support, but also child support, in the marriage contract, parties can also determine that if and when they have children, how the children will be educated, how they will be trained, issues in relation to decision making and parenting, and any other issues in order to settle their affairs if there is a breakdown. We have to know that when it comes to children, regardless of what provisions are made, the court may, because the court is very interested in protecting the rights of children, the court may override some of these provisions. There are some exceptions, though, to a marriage contract. What are some of those exceptions? Now, any provision in the marriage contract that limits the spouse's right to possession of the matrimonial home is not enforceable. Under the family law legislation, once parties are still married, even if they're separated and they've not been divorced, both of them have a right to occupation of the matrimonial home. And the courts will overturn this in a marriage contract as well as in a separation agreement. So any provision in any of those agreements that says in the event of a breakdown, either spouse A or spouse B has to leave the matrimonial home and there has not been a divorce, the court will not uphold that. It's unenforceable because both spouses have the right to possession of the matrimonial home until there has been a divorce. Another exception, and I mentioned it briefly before, is that the court will, in determining matters relating to education and moral training and decision-making or parenting with respect to a child, the court may disregard any provision that is in a domestic contract that the court considers is not in the best interest of the children. And so you may make a provision that, one parent will never see the other, the children will never have parenting time with another parent. If this goes to court, the court may rule, more likely than not, they will rule that that is not in the best interest of the children, and they will override that provision. The contract will still be valid. It's possible to have a valid contract and for the court not to uphold certain terms of the contract that you have. The court can also override terms related to provision, child support. Because, for instance, let's say the payer spouse earns $100,000 per year, and that contract has a provision for child support of $250, then that is not reasonable. And even though the contract may still be valid, if that contract was the court will override that provision. And the main reason for this is that the court is concerned about the best interests of the children. And even though parties have the freedom to regulate their affairs, there are these small limitations that the court will override those provisions in the domestic contract. Now, before I go to the requirements of a domestic contract, I'll speak briefly about the other agreements. There's a cohabitation agreement, which of course is similar to the marriage contract, but it applies to persons who are not married to each other, persons who are in a common law relationship. And then, of course, there's a family arbitration agreement. If there is an instance where parties cannot agree together to have a domestic contract implemented, but they still want to avoid going to court, they still want to avoid that lengthy and stressful litigation process, it is possible that they can agree to have arbitration. And arbitration is you appoint an arbitrator, and Section 51 of the Family Law Act provides for this. You can appoint an arbitrator who will determine the family law issues. It is not as formal as going to court. It is faster, and the arbitrator will represent both parties and make a decision on your family law issues. Now, before this can be done, you have to have an agreement as to who the arbitrator will be, where the arbitration will take place, and what are the issues that you want the arbitrator to decide on. And so you can determine that arbitrator will only decide on issues of child support, spousal support, education of children. The issues have to be named, and the arbitrator can only make a determination on issues that are mentioned in the arbitration agreement. And so arbitration is another way to go, and that's another domestic contract. And I'll mention briefly again the paternity agreement. Now, paternity agreement can be entered into by two parties who are not married and they've never cohabited, but they still have children together, and they want to make provisions, they want to agree on parenting and child support payment. And so they can enter into a paternity agreement. Obviously, if they're married, they will do a separation agreement. Or if they have cohabited together, they will do a cohabitation agreement. But if none of that exists and they simply have children without ever having cohabited or without ever having been married, then what they will have to enter into would be a paternity agreement that will later on become a court order. So they will outline parenting time, decision-making, and child support. And so that's, they can take that to court afterwards and have a court order. Now, let's talk about the requirements of a domestic contract. Now, contracts, generally speaking, contracts don't always have to be in writing. You can have oral agreements. And as long as parties can prove the terms of their agreement, the courts will uphold some oral agreements. But there are certain aspects of the law where the contracts must be in writing. And you're purchasing land or property, for instance, an oral contract will not work. Your contract has to be in writing. The other case where a contract has to be in writing is in the case of a domestic contract. It must be in writing. It cannot be oral. We cannot go to court and say, well, we agree that child support will be $400 per month, or well, we agree that there will be no spousal support. The court will not listen to anything that is not in writing. So domestic agreement or domestic contract must be in writing. The second important requirement is that it must be signed by both parties and it must be witnessed. Now, an agreement being witnessed is very important, but case law has shown that the court may relax that requirement for witnessing of the agreement, provided that the court is convinced that the agreement is reasonable and that the parties that made the agreement knew what they were doing. So it's important that the agreement must be signed and it must be witnessed. But just a note to say that it is possible that if the agreement is not properly witnessed, the court may still accept it, provided that the agreement is airtight in every other way. So no one should take the chance of having an agreement that is not signed by both parties and witnessed by both parties. Another requirement, and this is not necessarily a detrimental requirement, but it is very important, and that is independent legal advice. Now, an agreement does not have to have parties do not have to have independent legal advice, but if parties do not have independent legal advice, it leaves the domestic contract on shaky ground, that if it goes to court, there is a high possibility that the court can overturn the agreement. And why would the court be able to do this? The court can overturn an agreement where parties have not had independent legal advice because one party can say, well, I did not understand what I was signing. I did not understand this term of the agreement. I thought that this term meant this. I did not know that this term of the agreement meant something else. And so, if the court is convinced that the party is being honest in that they did not understand, that agreement will be overturned. But if there's independent legal advice, it is very difficult for a party to say, well, I did not understand the agreement. I did not know that this is what the agreement said, because you have a lawyer and your lawyer will advise you. And so even though independent legal advice is not necessarily a formal requirement of a domestic contract, it is a safeguard, and I would advise every single person to ensure that both parties have independent legal advice. And the reason it is called independent legal advice is because it should not be the same lawyer that advises both parties. Otherwise, it's simply legal advice. It's not independent legal advice. I have experienced persons saying, I can recall one man saying, well, it was my wife who chose the lawyer. And so the lawyer was acting in my wife's best interests. Don't choose the lawyer for your partner, because that's what they can say later on, that the wife or the husband chose my lawyer, and so that lawyer was acting in that person's best interest. So make sure that the legal advice is independent. It's really independent. Another reason why independent legal advice is very important is to avoid any allegations of duress, because some persons do force other persons to sign domestic contracts, or they might do it because they want to avoid certain negative influences. And so duress is a real possibility in a domestic contract, but if there's independent legal advice, then it is likely that the court will not uphold any allegation that someone has signed an agreement under duress. And I just want to mention quickly a 2024 case, El Rassi, White, and Arnold. It was decided, it was started in 2022, but the Court of Appeal decided the case in 2024. And in that case, the agreement was not witnessed by the respondent. So the parties agreed, they were separating, and they agreed that the respondent or the husband will transfer his share of the property to the wife. Now, after he signed the agreement, he had a change of heart and he decided that the property should be sold. And so the wife she filed an action in court that to allow the separation agreement to be enforced. Now, the court found that his signature was not witnessed. But like I said before, the court may overlook that irregularity of his signature not being witnessed if everything else was in place. In this instance, apart from his signature not having been witnessed, neither party had independent legal advice. And so the husband claimed that he was not fully aware, he did not fully understand the terms of the agreement. And based on that, the court determined that even though they would have been willing to relax the requirement for the agreement to be witnessed, because the husband claimed not, and they believed that he did not fully understand the terms of the agreement. Furthermore, some of the terms of the agreement were very vague. And if you're having a domestic contract, the terms must be, there could be no vagueness. The terms must be clear to both parties, and both parties must fully understand what the terms of the agreement are. And so in this case, apart from the fact that the agreement was not witnessed, the husband's signature was not witnessed, I think the wife had simply made a videotape of the husband signing the agreement. And even that, the court considered the manner in which it was made. They were not satisfied that everything was done in the manner that it should have been done. And so on that basis, all those circumstances taken together, the court overturned the agreement because of lack of independent legal advice, lack of understanding, the husband's lack of understanding, full understanding of the terms of the agreement, and of course, compounded by the fact that the husband's signature had not been witnessed. And so it's important to bear in mind that the formalities of the domestic contract must be adhered to. One should not assume that, okay, if this agreement is not witnessed, the court may still relax, the requirement. It is important to go into this making sure that it's in writing, it is signed, it is witnessed. Each party should have their own witness, and each party should have independent legal advice, a separate legal advice for each party. Okay, now let's look at how a domestic contract can be set aside. Even though the court respects parties' willingness to determine their own affairs, parties' willingness to guide how their family law affairs should be handled outside of the court, there are instances when the court will set aside a domestic contract. And one of the main instances of when the court will set aside the domestic contract is when there has been a lack of disclosure. It is very important that when making a domestic contract, especially a marriage contract and the separation agreement where financial issues will be dealt with, it is very important that full financial and other disclosure should be made. If the court finds that there has not been full disclosure, the court will set aside the contract. And the reason for this is, imagine party A and B entering into a marriage contract, and party B willingly signs this contract thinking that party A only has one property and only has $10,000. So they are willing to sign saying that they will want no part of anything that party A has. And then it's discovered afterwards that party A has several properties, and party A is a millionaire, and they didn't know that, so they signed a contract with that limited information. And it's not only assets, it's also debts. Party A may be drowning in debt, and this has not been disclosed to Party B. Party B may not marry Party A if Party B was aware of the amount of debt that Party A had. And so that party is entering into a marriage contract ignorant of all the relevant and important facts. Because we know that if we need all the facts before we enter into an agreement, and if we have certain facts, we may not enter into any agreement. This applies not only for domestic contract, any agreement. We need all the facts that will determine whether or not we will sign an agreement. And so in the case of a domestic contract, if there has been major lack of disclosure in terms of finances of one party or the debts of one party, the court will overturn that contract. Now, parties may opt to waive financial disclosure. Parties may put a clause in that agreement that says that they are aware of each other's finances and they waive financial disclosure. I would advise that each party complete a financial statement and list all of their assets and all of their debts just to ensure that the contract will stand up, because there's no point in doing a domestic contract, skipping over certain details that you can spend a little extra time to get completed and risk the possibility that the contract may end up before a judge and the judge may determine that there has been a lack of disclosure and so the contract cannot be upheld. It is always better for parties to spend the time, complete a financial statement, list all of their assets, list all of their debts, be open and upfront, because if anything is left out, then the court may upturn the agreement. I mean, if it's a minor detail, like a minor $2,000 or so, the court may not upturn the agreement. But if it's a major financial issue that has not been disclosed, then more likely than not, the agreement will be overturned by the court. Another instance of when a domestic contract can be set aside, and I mentioned this briefly before, a party's failure to understand the nature and consequence of the contract. And as I said before, that is why you need legal advice. That is why you need independent legal advice. There are some cases where one party will go online, get a contract, they will see a template of a contract. They themselves don't understand everything. They just take it, find it online. They fill in a certain part of it, present it to the other party to sign. They don't want the expense of having to pay a lawyer. So both parties sign without fully understanding the full effect of the contract, the consequences of the contract. And then when they find out that, certain things are not beneficial to them, they go to court. The court will set aside the contract because the court will realize that either one or both parties, none of them understand the full nature of the contract or the consequences of the contract. It is always better to get legal advice because there's certain terms in the contract that may need further explanation. And so, yes, the court, if parties don't understand the nature of the contract, the court will set it aside. And then, as I mentioned before, without necessarily setting aside the entire contract, there are certain terms within the contract that the court will not uphold, terms relating to possession of the matrimonial home and terms relating to child support and parenting. If these terms are not reasonable or if these terms are not within the best interests of the child. And so having entered into a domestic contract, having drafted your contract, having had your contract signed and witnessed and your legal advisor signing, saying he or she will sign a certificate saying that he provided or she provided independent legal advice that could be added to the domestic contract at the back. And having done that, what are the next steps in a domestic contract? Now, as I said before, the contracts have the same weight as a court order. So you're good to go. You have a contract. both parties have to abide by the contract, by the domestic agreement. You may decide to file the contract in court. That you prepare an affidavit and you attach the contract and you file it in court, and the court attaches a file number to that. The instance where this is most important is when there are support orders within the contract, and these orders need to be enforced by the Family Responsibility Office, or FRO. So before you can have FRO enforce support payments, and FRO enforces both child support and spousal support, and Section 7 expenses, where the payer pays expenses for things outside of support, things like dental work and extracurricular activities. These are all enforced by the Family Responsibility Office, so that if the payer does not pay, the Family Responsibility Office will take the steps to ensure that the payer pays the support. But before the Family Responsibility Office can enforce the terms of the enforcement terms, the domestic contract has to be filed in court. And then after it is filed in court and a support deduction order is granted, only then can it be sent to the Family Responsibility Office for enforcement. And so just in wrapping up, I just want to wrap up a bit by saying that today we spoke about domestic contracts. We looked at various types of contract. We looked at the ones that are most common, which are separation agreement and marriage contract. And we looked at the requirements that will ensure that your contract is airtight. The court will not overturn your contract. And we looked at the importance of having domestic contracts, of entering into domestic contracts, especially if parties wish to avoid lengthy litigation, if they wish to avoid the stress and the expense of litigation. And I mentioned the arbitration agreement, which is also a domestic contract, but it is where an arbitrator decides the terms for the parties without having to go through a lengthy litigation process. And so I thank you for listening.
Thank you so much, Valerie. That was a very informative presentation on domestic contracts. I'm sure we are all much more informed about the benefits of domestic contracts so as to avoid family law problems in future. And I thank you so much for emphasizing the importance of obtaining legal advice before entering into a domestic contract. And that's independent legal advice. It's so important for each party to have independent legal advice. So I know I heard you mention that several times, and it's very important that the parties appreciate the importance of independent legal advice in any domestic contract. So thank you so much. Thank you for being here today, and bye for now.
Thank you, and bye.